Okay, no. And a very good day. Happy to be joined via Zoom by a Carmi native, now down in one of the nation's hotspots in Louisville, or actually Louisville, sorry. I know that's important. Happy to be visited by Brenton Stanley, class of 2003, of course, mom and dad, well known in the local community. Mark and Becky Stanley. Brenton, thanks so much for taking a few minutes to visit with me today. I appreciate it. How are you?
I'm doing well. Happy to be here. Thanks for having me. Thanks.
Good. So talk to me about, first of all, what is it like down in Louisville right now? I think we're bombarded, radio, internet, TV. We're hearing constant updates about things that are going on and whatnot. What, somebody with boots on the ground, what's the atmosphere? What's going on there?
Well, in addition to dealing with COVID, we've also been dealing with over 100 days of protests in Louisville. And, people are not working downtown like they were in March and prior. And so that's had an impact on the city. And also the protests have had an impact and has sort of compounded the effect of people being absent from downtown. So if you drive through downtown Louisville right now, it looks totally different than it did 6 months ago. Everything's boarded up. It just kind of looks like a war zone right now. We have the National Guard here again, helping LMPD with protests and the control of the protests and the fallout from that. It's been a strange few months, to say the least.
Yeah, absolutely. And of course, what I wanted to discuss with you, you are in the field of law. I wanted to talk specifically about the Breonna Taylor case. Of course, that is all over the news right now. You haven't practiced criminal law for a few years, but you are familiar. You're a great person for us and our local community to get some information that is an educated opinion, somebody that actually knows about what we're dealing with grand juries and processes and things like that. You made a post on social media on Thursday that just sort of took off, and it had a lot of information in it. So I kind of want to start by talking about just kind of what happened and how we got what we got and what people should know about that.
Yeah, so there's a lot has happened in the last few months. We've learned a lot about the Breonna Taylor case. It took a while before the media kind of took hold of it and it became a big news story. But essentially what happened is Louisville Metro Police Department officers went to serve a no-knock warrant on her apartment because they apparently believed that she had some involvement in drug trafficking. Now, so they went in what I understand to be the middle of the night and conducted a raid on her apartment. And during the course of that raid, she was shot several times and killed. The police officers did not end up finding any drugs or any evidence of a crime being conducted inside the apartment. Her family members and friends have certainly been adamant that she didn't have any such involvement. The target of that investigation, as I understand it to be, was an ex-boyfriend of hers who she was not dating anymore. At the time the raid was conducted, she was at home with her current boyfriend, Kenneth Walker. He has been, he's taken the position that the police officers who conducted the raid did not announce themselves as police officers, and that could be important. But what happened was, to the best of my understanding, of course, a lot of this is not publicly known because a lot of the investigation is still ongoing or
certainly
subject to confidentiality. But what he has maintained throughout this is that officers busted in Breonna Taylor's door where he was staying, and he fired a shot as a warning shot or self-defense. And in response to that, officers really just kind of unloaded on the apartment and killed Breonna Taylor in the process. Also, bullets or projectiles, at least, went into some of the neighboring apartments. And so because of her killing, there's been sort of a public outcry here and a lot of protesting for criminal justice reform, for justice for Breonna. A lot of people have been calling out for the officers who were involved in that raid to be held both civilly and criminally accountable. There was a big news story last week. They reached a civil settlement with Breonna Taylor's family for $12 million. The city of Louisville is going to pay them $12 million as a settlement of the wrongful death suit. The big announcement this week was, what is our Attorney General going to do? Normally, crimes in Jefferson County, Kentucky, which is Louisville, would be felony crimes would be handled by the Commonwealth Attorney's office, which is the office of Tom Wine, where I used to work. They recused themselves from this case. I would expect that was because some of the officers who are involved are key witnesses in other ongoing cases that they are prosecuting. And so they recused themselves and asked that the Attorney General either handle it or appoint a special prosecutor to handle this case. And so our Attorney General, Daniel Cameron, has been heading up the investigation. And this week, the results of that investigation were announced following a grand jury hearing and investigation. One of the officers who was involved was indicted on 3 counts of wanton endangerment in the first degree. Those 3 counts of wanton endangerment are not for the killing of Breonna Taylor. Rather, those counts of wanton endangerment are for projectiles that, I guess, from his weapon, entered a neighboring apartment. And so there were 3 occupants of that apartment. And so those 3 counts are one for each victim, the people in the neighboring apartment. So a lot of people were really disappointed to hear that there are no criminal charges that are related to the killing of Breonna Taylor.
Right.
And as a former prosecutor and somebody who's been watching this closely, Louisville resident, I have to say I was pretty disappointed as well to see what the results were.
So, and I have seen it posted that basically the only charge or indictment or the only thing they found were for shots that didn't even hit anybody. That's one point that people have made. And then there was also, there's so many pieces to this and so many different directions. From the no-knock warrant, which is already, there's a whole bunch going on with that as far as repealing it and changes within that, to just potential failures within the police department itself in how they staked out or even targeted the Taylor's home. Whenever you look at, I think there were 5 or 6 different raids planned for that night, and they were all on an entire other area of Louisville. And then there's Breonna Taylor's place, which is not a rundown area. It's it just, and it's always 2020, hindsight is 2020, but you look at it and you go, well, that just doesn't make sense. So there's a lot. Is there more to come because people are so upset with this? Is there a possibility for criminal charges, things like that, or is it done?
There's certainly a possibility that might happen in the future. In Kentucky, there is no statute of limitations on felonies. So it could be that, someone else is elected Attorney General after Daniel Cameron's term is up and reopen the investigation and could potentially charge someone. Having said that, I think that's very unlikely to happen at this point. I think the intention of Daniel Cameron was to conduct an investigation. At the end of that investigation, conduct a grand jury proceeding and indict what you're going to indict. he has said publicly that one of the reasons why it took as long as it did is because they were waiting on some ballistics results, which came in. That's not something you normally have at that stage.
Okay.
That's something he was waiting on. Most of the cases that I worked on that had ballistics as a prosecutor, you don't get that stuff until after an indictment's been returned. He wanted to get that ahead of time to inform his decision. My understanding is he wanted to make sure that anyone who is going to be indicted by this stage, it has been indicted. I wouldn't expect him to go back and charge someone else in addition to what he's already done. It's my understanding there's also a related FBI inquiry.
Mm-hmm.
The scope of that I'm not real keen on. Now, the way that would be charged with a federal crime and a state crime, and you could be acquitted of one and you could still be tried for the other. Double jeopardy doesn't attach that way. And I know a lot of people have an understanding of what double jeopardy is. Once you're acquitted of a crime, you can't be tried again. Nobody's been tried yet. But even if you're tried and acquitted in state court, you could be tried potentially and convicted in federal court of a substantially similar crime.
Okay. Now, of course, whenever we get into the no knock, all I had heard, and you would certainly know more about this than I, of course, the Walker and Taylor said that, or Walker said that they never heard any announcement or anything like that as to identify as to who it was. It's after midnight. I think there was one person, and you may know better than me, that said that they heard somebody announce. Is that information that grand jury got? Talk to me more about what the grand jury actually got to see. Sometimes they refer to those grand juries as rubber stamps, right? So what information did they get? It almost feels like we as the public are getting way more information than maybe what the grand jury even got, which could only fuel flames if you don't get the desired outcome.
Well, the grand jury process in Kentucky and most places where it's used is very one-sided. So the prosecutors have an opportunity to present all the evidence that they want to present. A criminal defendant can testify in their own grand jury proceeding, but that almost never happens. The defense attorney would usually not want them to lock themselves into testimony before they've gone to trial. So that's, as a practical matter, it just doesn't happen. But a grand jury proceeding is required under the Kentucky Constitution. It's different than in Illinois. The criminal procedure is pretty different in Kentucky. One of the main things that's different is if you're ever charged with a felony in Kentucky, you have to be charged by through the grand jury process, unless that's waived, and there's a lot of explanation that goes into that process. But 9 times out of 10, you got to have a grand jury for a felony case in Kentucky. And so the way it happens is you bring an officer, usually is the lead investigator on a case. You bring them into a room with 12 grand jurors. They read a prepared statement on the record, which is usually an audio recorded transcript. The grand jurors actually have a chance to ask the witnesses questions if they're unclear about something.
Okay.
And any witness, it doesn't have to be just one witness. There can be multiple witnesses. It sounds like in this case there probably were multiple witnesses, but it's all at this point it is all a secret process what happened in that specific investigation. It's not public record. The only way that a grand jury proceeding becomes public record is when someone is indicted. The person who is indicted then has a right to get a transcript or the audio recording from those proceedings. Now, there are certain pieces of that process that are not transcribed or audio recorded. One of the main important pieces that is not transcribed or audio recorded is the prosecutor's recommendation, which is secret. So after witnesses testify, the recorder's turned off, the witnesses go out of the room, the prosecutor has a chance to talk to the jurors directly with nobody else in the room. There's no defense attorney. There's no judge. There's no judge that presides over these, a witness that testifies at a grand jury proceeding. And the prosecutor can say, I want you to indict this person on these charges. I think that's what you should do because I think that's what is appropriate in this case. Now, grand jurors don't have to follow the recommendation of the prosecutor, but as a practical matter, they pretty much always do. There's a saying that a grand jury will indict a ham sandwich if a prosecutor asks them to, because they just kind of do what they're told. That's just the way it works. They don't get enough information usually to start questioning what the prosecutor tells them, because again, it's typically very one-sided. It's not an adversarial process like a jury trial is that you normally see on TV, where witnesses are cross-examined, right, and the two sides make competing arguments. It's very one-sided, and so grand juries do, by and large, what prosecutors ask them to do. So a lot of people were questioning this week whether additional charges were presented to the grand jury and that the grand jury just decided not to indict them. And that's certainly a possibility. That is not usually how it's conducted. There are some times where a prosecutor will use a grand jury investigation as a way to sort of wash their hands of a case that they don't want to have to make the tough call on. It's a way to sort of push it off or punt onto the grand jury and say, oh, look, it wasn't me who didn't indict, it was the grand jury. Or it wasn't me that dismissed the case, or it wasn't me that settled the case for a misdemeanor when it really should have been a felony. It was the grand jury. And that's something that's done. I've seen it happen before. And my intuition is that is what happened here.
Now, Officer or Detective Hankinson, I think, was the only one that was indicted, and he faces 1 to 5 years on each of those charges. They could run concurrently, they could run consecutively. So he could have, I suppose he could be acquitted, or at most he could face 15 years. Is that accurate?
That's correct. Yeah. So on what, excuse me, as the charges have been indicted so far, 3 counts of wanton endangerment in the first degree are Class D felonies in Kentucky. Class D felonies carry a possible sentence of 1 to 5 years in prison. A trial jury would get to make a recommendation as to whether those, assuming that they convict, which there's certainly no guarantee of that. Assuming that they did convict, they would get to recommend whether they think that the sentences should run consecutively or concurrently, and ultimately would be up to the trial judge at sentencing to determine how that would work. But another thing I would like to add is we don't know. Nothing's public at this point what was presented to the grand jury. Right. Daniel Cameron made several statements in his press conference this week about his office determining that the officers were justified in their use of force. And what happened apparently in this case is that he determined that the officers who shot Breonna Taylor were justified in their use of force. And so that has raised all kinds of questions about, well, what does he mean? What is he basing that on? What were the witness statements? What did the officers say? Who testified at the grand jury? And what did they say? And those are a lot of questions that remain at this point because the grand jury proceedings are secret. And a lot of that may never come to light. It may be that they never intended to indict anyone except for Detective Hankinson. His press conference to me raised a whole lot of questions and probably raised more questions than it answered.
Okay. And we've got this whole thing where Kentucky's got stand your ground, and then it just seems like it's a recipe for disaster whenever you've got stand your ground rules that are okay, but then you've also got no-knock warrants. So, and maybe this is a question for law enforcement, but something's got to be done about that, right?
Yeah.
One or the other.
There have been a number of legislative efforts since her killing to address the no-knock warrant situation, both at the city level with ordinances and at the state legislature in Kentucky. I think by and large, no-knock warrants are just a bad idea. Obviously, here in hindsight, we look at this and we think, yeah, I mean, you kick in somebody's door in the middle of the night without announcing who you are, it's completely foreseeable that they might try to defend themselves. And that's
Sure.
what happened here. And I think, even the most staunchly conservative supporters of the police recognize that people have the right to defend themselves with a firearm in their own home. And so what you have here is really a sort of competing claims of self-defense. Kenneth Walker saying, I'm defending someone who I don't know who they are, kicking in my door, or in the door where he was staying in the middle of the night. And you have police officers saying, oh, we went in on a raid and we were fired at. Officer Mattingly was hit in the leg, severed his femoral artery and had a pretty significant injury, is my understanding. Right. And so, it's their claim we were defending ourselves against being fired on first. So it makes it hard to sort out. Under Kentucky's standard of ground law, it becomes really important, the idea of did they announce themselves or did they not announce themselves? Because if they hadn't, Kenneth Walker is entitled to self-defense. If they did, and he knew that they were acting in their official capacity as law enforcement officers, then he didn't have a right to self-defense. And so what these neighbors said and what what Mr. Walker says about what he heard and what they said, at the time they busted in the door, that's I think significant and can be
right. And as far as I know at this point, Mr. Walker has adamantly from the get-go said he never heard them. And correct me if I'm wrong, there's only one neighbor that said, yeah, he heard it announced at any point. And who knows if it's loud enough to raise somebody from asleep either. I mean, there's just so many things. At the end of the day, it's just sad that it happened, but in order to get better as a society, don't we have to look at this and, try to correct some things?
Yeah, and based on what I have seen in the media as far as what's been reported and what's been disclosed by law enforcement, there is, as Daniel Cameron pointed out in his press conference this week, one neighbor who says that he heard police officers announce. The timing of the announcement is also important too. Did you hear them announce after they had already fired shots, or was it before? Was it before they opened the door? So all of that sort of raises questions. But what's been reported is that out of the dozen or so neighbors who have been interviewed, only one said that he actually heard officers announce. And I've also read that the first two times that person was interviewed, he said he did not hear officers announce, and then later changed his story and said, yeah, I did hear them. So there's definitely a question of fact there. The thing that's frustrating for me is that all of this has, rather than being decided out in the open, in an open court where there's a public record that you can go in and see what happens in a courtroom, and the two sides make arguments to each other and witnesses testify, and you can go in, you can see it, you can get copies of the transcripts, you can get video recordings of the testimony. This all happened at the grand jury, where we don't know what they said. We don't know what was heard, what was done. And it's frustrating for a community that has been calling out for increased accountability and transparency, that this was done in using a secretive procedure, which is what the grand jury process is.
Are there reasons? There's got to be reasons why it is secretive. I don't know if I can ask you for an example, but there's got to be a reason why that information is not public in certain cases, right?
Sure. So There are definitely reasons why, at least to a certain extent, it does remain secretive. For example, in a narcotics investigation, you might have dozens of people in terms of middle level distributors, low level distributors, informants, people who are users. A lot of times they end up flipping and testifying against each other and giving information to law enforcement.
Mm-hmm.
And a lot of times it's to protect the safety of witnesses and people who are involved in the investigation.
Okay.
You wouldn't want, it's just like the way that an ongoing police investigation open to a public records request or a Freedom of Information Act request, because there could be information that could legitimately endanger someone's safety.
Okay.
The way that grand jury proceedings are typically used in Kentucky, I don't think that that's a real concern. And that, having said that, I didn't work in the narcotics unit, so I didn't deal in those sorts of cases. I just dealt with them sort of at an arm's length. Occasionally, I might handle a case that had an element of that to it. But that is always a concern in those cases, that you could be giving up a confidential informant and putting them in danger.
Right. It is of note. You mentioned that you worked in Thomas Wine's office. You also went to school with the Kentucky Attorney General, correct?
That's right. Yeah, he and I went to University of Louisville's Brandeis School of Law at the same time. He was a year ahead of me, but we overlapped for 2 years. And so, I know him. He's a very likable guy. You'd like him if you met him. A nice guy. But I certainly have some questions about what he's done here.
Anything else? I'm sorry, go ahead.
I was just gonna. I have some criticisms as you pointed out. I posted on social media and some things that I've mentioned.
Right. Anything else that I missed that's important for people to know? I mean, we could probably spend, on any cable news network, we could probably spend an hour and a half or several segments on this, but just for I thought it was a great opportunity for our local area to hear from someone local who just knows more about it than we do, and to maybe clear some things up. Is there anything else that people around this area should know about it? Because they're obviously hearing about it.
Yeah, so I did notice following Daniel Cameron's press conference the other day that there were a number of news agencies, national news agencies, that I thought got the headlines really wrong. There were some that said things like verdict return in the Breonna Taylor case. And I mean, you could maybe consider that to be a verdict when the grand jury makes a decision, but that's not usually what you would call a verdict. It's
Right.
It's not a trial. It's not a trial where guilt and innocence is determined. So it has been tried in terms of determining their guilt and innocence yet. So that is one thing that I think got wrong. There were also a number of headlines that said one officer charged in the killing of Breonna Taylor, but there were no charges that were related or stemming from her death. And so
They're using the completely wrong nomenclature for what actually happened.
I think there were a lot of news agencies who wanted to be first to break the story and got the particulars wrong.
Yeah, I don't disagree that that happens, especially in a high-profile case. Everybody wants to be first, and sometimes they don't check before they hit post or submit or whatever.
And to be fair, there are a lot of attorneys who don't understand all the procedure. It is something that is the grand jury process, the way it was used, is peculiar to Kentucky, and a lot of people who practice criminal law in other states don't have a good understanding of how it worked, because quite frankly, it is convoluted and can be confusing. So I wasn't surprised to see that some places got it wrong, but I would hope that there are enough people getting information out there that people's understanding can be corrected.
Right. Well, very good. Thank you so much for visiting with me today. I want to give you a moment. I guess we're not going to see you at Corn Days this year. Of course, COVID got that as well. Anything else going on with you that's good that your friends, family would want to know? What's happening with old Brenton?
Yeah, actually, I've been, people who know me know that one of my hobbies is building guitars, and so I've got my next one just about ready to go here. So.
Excellent, beautiful, a Brenton Stanley exclusive.
Thanks.
No, thank you. I appreciate your time. You take care of yourself, and we'll talk to you soon.
All right. Bye.
All right.